Good afternoon, Santa Clarita Valley. This is Dennis Kennelly. You're on the legal line. With me is our guest engineer, Nikki London, the lead singer of London Rain, whose music you just heard. That's our bumper, and we get a lot of calls about it. And they're available on londonrain.com if you want to hear more of what London Rain has done. Our engineer is Aaron Delatorre. Our subject today is mediation. Our guest, Peter Marks, and we'll get to Peter in a minute. Peter is a very experienced mediator, been doing it a long time, and has some really interesting perspectives on the process, which I think, as we'll get into it, you'll discover most people don't understand. I think it leads the league in misconception. As we do every week, just kind of looking at the landscape, what the hot issues are nationally. If you would consider Obamacare a legal issue, and I would, because it involves employment law, because for some reason in this country, insurance and medical benefits were tied to employment for the longest time. And if anybody wants a half-hour treatise on how that happened, and it goes all the way back to the post-World War II days, I'll be happy to do it. But I think it's not what the audience needs to hear. What the audience needs to hear, and I think what the politicians are looking for right now, is what does changing Obamacare mean? And I think when they go to their town hall meetings, the most common question that's going to be asked by everybody sitting in that seat in the town hall meeting is, how is it going to affect me? What am I getting now? And what am I going to get under the new proposal? And if I'm going to get less, I'm not going to be happy. And if a whole bunch of us are going to get less, or a whole bunch of people, the people that pass whatever the new law is are going to have an angry electorate to face. And what do angry electorates do? They throw the bums out. So I think that's what's going on in Washington now. I just happened to catch House Speaker Paul Ryan at his press conference this morning explaining in great detail how Obamacare is going to work. But I think somebody can make a fortune by developing an app that you can fill in your situation and all of your stats, and it's going to tell you how much you're going to make or lose under the new proposal. And I think this is going to be a very individualized decision, because politicians very often ask, are you better off now than you were 4 years ago, or are you worse off? Well, this one is going to be really, really, really measurable, because how much did I pay? So more to follow. This battle is not going to be solved in a week. It's not going to be solved in a month. I think it's going to take 4 or 5 months to resolve. And I think whichever way it comes out, the electorate will get a real good chance to either signify their approval or disapproval in the congressional elections in 2018. But enough for politics. Now to the subject of mediation. And our guest today, and I'm really, really happy to have him. I run into him a lot in Los Angeles County and Beverly Hills Bar Association labor and employment law and entertainment law meetings, is Peter Marks from Beverly Hills. And Peter, why don't you give us a little bit about your background? And then Peter and I, obviously talked before he came on, and he has an excellent presentation that he brings to the parties at the start of a mediation, which will help him explain to you exactly what the mediation process is. Peter, go on.
Well, good afternoon. It's nice to be on the show. Thank you for having me. My background, I'll be very, very brief. I've been a member of the bar for a little over 50 years now. I started when I was about 7, and I've been working as a mediator for over 25 years. And at one time, my law practice included both what we call litigation court work and transactional work. I pretty much closed down the law practice now and stopped litigating years ago because it tended to conflict with my mediation work. Now, when I commence a mediation, usually the lawyers are almost invariably, especially these days, very familiar with the process, but often the parties aren't, and most of the time, not always, but most of the time, they've not experienced a mediation, and sometimes not even a lawsuit. And I found that the most accurate and easily understood manner in which to explain the mediation process, and it's important that the parties understand how the process works, is to contrast it with litigation, court proceedings. And so I'll say something like, now you have a lawsuit here, or you may have a lawsuit here, and if it goes to trial, it's going to be literally kind of fought out in an adversarial process. It is inherently an adversarial process. And what that means in the real world is that the lawyers for each side will present what we call evidence, arguably supporting their party's claims, evidence usually consisting of either testimony and or documents, sometimes other things, but usually that's what comprises evidence. Then once the evidence has all been received, the parties then, the lawyers rather literally argue, it's called final argument or closing argument, to the jury or judge if there's no jury, to try to persuade the judge or jury why the verdict should be in favor of their respective clients. And then the judge or jury decides. After this adversarial process takes place, a third party decides the case. Some people say imposes a decision on the parties, but that's the way it's resolved. You fight it out in front of the judge or jury makes a decision. And then I tell the parties, for purposes of today, for purposes of this mediation, I want you to forget about all that. I'm not a judge. I'm obviously not a jury. I don't decide who wins. I don't decide who loses. I don't decide who's right. I don't decide who's wrong. I don't decide anything at all. My function and the whole concept of the process is completely different. My function is to help the parties come to an agreement whereby they resolve the case, not me or not any third party. They try to make an agreement, and my job is to help them get there. And I tell them, even though you may have been fighting about this for a long time, both prior to initiating any court proceedings and otherwise, for purposes of today, I want you to think of this as a collaboration where you try to work together to reach an agreement which, to the greatest extent possible, satisfies what we call your interests. And that's a particular term. It's kind of a term of art in mediation, and we'll talk about that in a minute. So that's the first distinction between court and mediation, is that mediation is not adversarial. Rather, we try to bring the parties to an agreement whereby they resolve the case. And I should say at the outset that mediation is a consensual process, unlike court, where the judge sits up there and rules over everybody. The mediation is controlled by the parties. It's a consensual process. They really control it all the way along, down to the question of when to take breaks, if they need to speak privately with their lawyers, all that sort of thing. If they want to raise certain issues, and I'll talk about that in a minute, the parties control the process, not the mediator. Now, the next distinction between mediation and court, and I think this is the most important and what really makes mediation work, is that if you try the matter before a judge or a jury, the kinds of information, the evidence that you'll be able to submit to the jury is highly restricted by what we call rules of evidence. And the theory is that if you limit the kinds of information, the kinds of evidence that the jury sees and hears, you increase the likelihood that that information will be truthful and reliable. So it's very, very, very restricted.
Not only that, Peter, aren't the remedies also restricted in
I'm going to come to
proceeding?
That. You're way ahead of me. I'm going to come to that. You're absolutely right. They are restricted in court, and in mediation, of course, it's an open table. And I'll come to that in just a second. You're absolutely right. But what this means in terms of no rules of evidence is that anything that is on anybody's mind should be raised, because you never know what may be important to the person. The job of the mediator, at least as I perceive it, is to try to understand, to ascertain, to determine what the true interests of the parties may be. In other words, what's really motivating them in this case, what's really bothering them, what's really of concern to them. And so particularly in a case where you have a long-term relationship, either a business relationship or a personal relationship, many times over the course of that relationship, for example, in a business, maybe two parties were doing business for years, and it was very lucrative, and all was wonderful, and they were making, serious money. But maybe 2-3 years ago, there was a little problem arose, and it never really got addressed, and one party felt he or she wasn't being treated fairly and so forth, but let it go because, it's not a perfect world, and we move on, and business was going great. But then now a new problem arises, and that same party feels aggrieved again, and he or she says, I can't let this go again. I can't let this happen. Well, in court, chances are, whatever happened in that previous dispute would be what's called irrelevant, and the judge would not allow it to be presented to the jury. And yet that may be what's really driving one of the parties in the case. So in the mediation, I encourage the parties right at the outset. I say, if that's bothering you, something that happened 2 or 3 years ago, even if it's very, very remote to what's involved in the case today, maybe tangential, but if it's bothering you, I want to hear about it. Because what we do is we contrast your interest with your positions. Your position in the lawsuit is that one side, you're right, the other side's wrong, and either you don't owe any money or you're owed a lot of money, depending on which side of the case you're on. That's your position.
Right.
But in mediation, we go beyond that. We look at your interests. And what's really interesting on the hypothetical that I've raised, what's really of concern, of interest to the one party is that there's what's developing to be a pattern of problems, and going back to the earlier problem. Well, if you surface the earlier problem, you don't necessarily resolve it, but just by mentioning it, by getting it on the table, that party may feel more comfortable in moving forward. And also, if it's mentioned to the other party may not be aware of how serious a problem it was, or even that it was a problem. And he or she will say, well, gosh, I didn't realize that, and if I'd known that, I would have done such and such. And then you clear the way to move forward. And that's a critical element of mediation, is getting to the party's interests and getting the bad feelings out of the way, and then you can move forward. So that's the second, and I think the most important distinction. The third thing that's really important in mediation is that it's confidential. And the significance of that, and the reason for that, and it's a fundamental policy decision or aspect of mediation, is that you don't want the parties to a mediation to worry that if the case doesn't settle and it does go to trial, something they said at the mediation can be used against them. It can't happen. California Evidence Code is very strict on that. The California Supreme Court has consistently upheld that confidentiality requirement, so that nothing that is said in the mediation or written for purposes of the mediation may be used at trial or in any of the legal proceedings which may follow. And that gives the parties a comfort level which they might not otherwise have in terms of being forthcoming and accommodating. So those are the three distinctions. This is what I lay out to the parties at the beginning of the mediation, because I want them, it's critical that they understand the concept so that they can work with it and use it to their best advantage. And now getting to your point, Dennis, yes, absolutely. Another critical element that distinguishes mediation is the question of remedies. As I may have mentioned a moment ago, in court, generally speaking, the remedy that the plaintiff may obtain is usually money. Usually money. There is, as Dennis, of course, there's also occasionally the opportunity and the availability of what we call injunctive relief, where the court issues an order requiring a party to do something or requiring a party to refrain from doing something. That's called injunctive relief. But most cases, the remedy is basically money, and that's it. Now, in mediation, we take a different approach. We try to throw as many possible remedies on the table as we can think of, no matter how off the wall or probably not useful or not helpful or whatever. But we throw everything on the table. It can be anything. And then we sort of mix and match. We discard those potential remedies which we don't believe will be helpful to resolving the case. And slowly we get down to what is we think will work and what is suitable for the parties. Now, just to give you an example, for example, in an employment case, let's say it's a case where the employee felt that he or she was wrongfully terminated for whatever reason and is owed back pay and so forth. Well, the employer may not feel that, there may be a legitimate dispute as to how much is owing, even if the employer agrees that something is owing or is willing to pay something. But it may not be enough. Well, what else can we throw on the table? Well, the employee may want a letter of reference, which the employee, interestingly, and sometimes are willing to give if it's carefully crafted, or maybe want help in finding a new job, or in a case involving a person's reputation, the aggrieved party may not be so concerned with money, may want a statement. And I've actually had, not many, but it's come up once or twice maybe, where we've actually, although mediation is confidential, we've actually issued, by agreement of all concerned, a public statement clarifying what happened that in the incident that gave rise to the case to begin with, so that the party's reputation is perhaps restored.
Or
and you can't do that in court. Normally in court, you just get money.
Yeah, another example would be changing the characterization of the termination, where somebody was fired.
Sure.
And that's always a question you're asked going forward, especially if you're working for the government or have to take a polygraph test, to have the nature of the discharge changed to a resignation by mutual agreement.
Sometimes sealing the records of what occurred, the employee's personnel file, so that can't be discovered in any fashion, or maybe destroying those records so that it doesn't come out later in some fashion that would be harmful to the employee. You can be as creative as you want. You never know what people may come up with. It's particularly useful, again, in disputes where there's a long-term relationship, because not only can you resolve the instant dispute, but you may be able to put the parties back together again, which wouldn't happen in court. And perhaps establish a mechanism, which we incorporate in the agreement that's signed, for addressing the dispute if it arises again in the future, so that you can cut it off at the pass, deal with it, and not have the breakdown and the disruption and, frankly, the loss of funds that usually is inherent in these kinds of disputes. So you can kind of pave the way. You know where this is really effective is in homeowners' disputes in condominiums.
Yes.
You got two neighbors going at each other, really unhappy with each other, and you don't want to just solve the instant dispute. You want to at least, they may never be best friends, or best friends forever, whatever that, I'm not young enough to know all these expressions, but anyway, they may never be best friends, but you may be able to establish some template or format for dealing with problems as they arise, so that the neighbors' lives aren't completely taken over by these disputes. Because if you've ever seen these disputes and these homeowners association disputes, they can be brutal. And so by establishing some sort of mechanism for dealing with future disputes as they arise, and maybe even putting some potential remedies in there if you can anticipate what those disputes are, you can really provide a service for the parties that goes way beyond resolving the instant dispute, and indeed perhaps prevent or at least make arrangements to address disputes which may arise in the future. And again, in court, that's much less likely to occur.
Understood. There are three stages at which mediation normally comes into play. And they're normally tied to litigation, because most of the mediation that at least lawyers get involved with involves cases that have already been filed. But one of the interesting times that you can mediate a dispute, and Peter, you've done these cases, I've done these cases, is before a lawsuit is filed. There are certain kinds of cases that if the parties are really serious and want to get it resolved, there are reasons that you don't want the public record of filing a lawsuit. For example, if you're a vice president or a president of a big company and you think the company violated your contract or did something wrong, and you think a great litigation case, but you are not particularly interested in having the word plaintiff attached to your name, because lawsuits are now a matter of public record, and HR departments are very good at doing background checks. And if they find out that a prospective executive has been a plaintiff, that is not a factor in his favor. Another
Especially
one.
If he's a plaintiff, he or she's a plaintiff in a lawsuit against a former employer.
Exactly. And the second one is, and it's interesting, and we'll go into some details on this later after our break. I've had Defense Department cases where an employer employee wants to sue for retaliatory discharge based on whistleblowing. Well, if this individual files the lawsuit, the defense contractor feels morally and publicity-wise obligated to defend the darn thing all the way to the death. And if you don't file it, if you do it pre-litigation, you give them a lot more flexibility in resolving the case, and it never goes public. So those are a couple of factors where you do pre-litigation mediation. Peter and I will talk about that and the other two stages of it after our break. You're on KHTS. Phone number is 661-298-5487. Email is dennis@hometownstation.com. You can watch us live on Facebook. Phone number again, 661-298-5487. We'll be back after the break.